What percentage of attorneys go to court and don't even know there is such a thing as examiner notes?
More than you would expect.
It's shocking, isn't it shocking?
Yeah,
I,
it's quite shocking that they don't know to check the examiner notes and cure defects. And um, I usually get a good smile out of it, but they're not enjoying their time as much as I am.
and it's what's funny to me now. So what we're talking about is when attorneys file papers or petitioners file papers in the court. In the court, there is somebody who reviews the documents before the judge sees it, called the probate examiner. In LA County, we call them probate attorneys. In some counties, they call them probate clerks. So the different names for the job of, and often they're attorneys or they're entry-level attorneys who are reviewing the documents and kind of eyeballing everything for the judge and pointing out the key parts and then looking for common mistakes and pointing them out ahead of time. And in most counties, LA for sure, San Diego for sure, has a system where there's what he's referring to as examiner notes, or in LA County we call probate notes. They publish what those defects are. It's kind of like turning in your paper in high school, and the teacher says, well, I'll review your paper, and you have another week to correct all the mistakes if you want to get an A. I was kind of student that would take the paper and correct it. They found 10 typos. I corrected those 10, retyped it, got an A. But there are attorneys who don't even know their notes, and they're taking big fees for these probates. It happens all the time. So it's not just me saying that. And of course, Zach, we don't want to disparage your colleagues, but what we do want to do is raise the standard of performance of your colleagues. And I think rightfully, so we can say it is surprising how many attorneys are like in real sharp looking dress suits from decent firms, and they even know there's probate notes.
Yeah, it's frustrating because as an opposing counsel, I would like the case to advance. And if there are incurable defects or major defects that such as service or process or notice of hearings that you can't waive, those are true defects that are flaws in your petition, it will slow up the case by 2 to 4 months because you'll get continued till to come back in 4 months from now at the next available court date because there's only 3 judges, they're busy. So it just drags on, and probate's already slow to begin with, and you cause these types of errors that make it even slower. It's quite frustrating to advance cases.
Not want to hold up the probate judge, right? It's like a train going downhill. Get out of the way. That train's going down. If you're the guy holding it up, they're not going to be happy. True or false?
True, very much true. But sometimes it's very much a useful tactic. I will say, by law, you're entitled to evidentiary hearings for so many different issues in probate. So if you want to contest probates, it's very easy to contest and drag out the process for a contested appointment or a litigated case. But yeah, you don't want to. If you don't want it to go slower, you need to do everything you can to make sure you can get a ruling as quick as possible, because otherwise you're going to be waiting a couple more months.